the state office building for me one time, and they would not let me bring my equipment with me. And I, I was like, well, then you're going to pay me
Yeah. Well,
$8,000 if something happens to it.
okay. All right. Well, we're good to go. All right. Let's get on the record. Welcome to Docket 6630 CE 317, the application of Wisconsin Electric Power Company for a CPCN related to the South Oak Creek facility, the proposed combustion turbines. My name is Michael Newmark, the Administrative Law Judge for the PSC. We're here for a pre-hearing conference, all gathered on Zoom. And first thing we should do is just take appearances on the record. So I'm going to switch over to the appearance service list, and we'll begin with Advanced Energy United. Who's representing them?
Thank you, Your Honor. This is Nikhil Vijayker, the law firm in Keys and Fox, representing Advanced Energy United.
All right, thanks. I'll continue down here with Citizens Utility Board.
Good afternoon, Your Honor. Kara Coburn-Ferris with the Citizens Utility Board.
Okay. City of Milwaukee.
Good afternoon, Your Honor. This is Assistant City Attorney Tom Miller on behalf of the City of Milwaukee.
Okay. Clean Wisconsin.
Good afternoon, Your Honor. Brett Cordy on behalf of Clean Wisconsin.
Okay. Healthy Climate Wisconsin and Union of Concerned Scientists.
Good afternoon, Your Honor. Grant Snyder of the law firm of Keys and Fox LLP.
Okay, great. And I have you guys listed combined, but I think as separate entities, I'm going to separate that out in the future, just so you know.
Understood.
Public Service Commission.
Assistant General Counsel Stephanie Bedford, appearing for the Public Service Commission.
Renew Wisconsin.
Ori Walsdick for Renew Wisconsin.
Sierra Club.
Megan Walkspress on behalf of Sierra Club.
Okay, Walnut Way.
Attorney Eduardo Castro appears on behalf of Walnut Way.
Okay, so Attorney Castro, I didn't notice your name on the appearance slip. If I was mistaken, appearance slip, I didn't mean to say that. The notice of appearance, request to intervene. If I'm mistaken, I can double check, but if not, if you could submit a notice of appearance for us as well.
Yeah, I'll double check because Attorney Khalil is no longer at our law firm, so there might have. I will confirm that and get a notice of appearance right away if I'm not on the list. So,
okay, thanks. Wisconsin Electric Power Company.
Good afternoon, Your Honor. Kate Phillips for Wisconsin Electric Power Company. I also have Patrick Proctor Brown from Quarles and Brady, also representing Wisconsin Electric Power Company. Thank you.
Okay, and I might have missed your intervention as well, but if you need to file a notice of appearance, please do that as well.
Yeah, Your Honor, I believe that we did, but we'll double check. Thank you.
Okay, yeah. Sometimes I make the list in advance, so I might have missed it. Okay. Wisconsin Industrial Energy Group.
Yes, good afternoon, Your Honor. Steve Heinzen for the Wisconsin Industrial Energy Group.
Okay. And Wisconsin Local Government Climate Coalition.
Good afternoon, Your Honor. Matt Frank from the law firm Murphy Desmond, representing Wisconsin Local Government Climate Coalition.
All right, great. Thanks. Well, thanks for all joining us. I'm going to remove the service list here. So with our regular notice of pre-hearing conference routine, we identifying the parties, the issues and the schedule, other facilitating matters. We did have an order on intervention, so we do have just display the notice here. We do have the applicant and 11 interveners. That's already been determined. The issue, it's kind of our standard construction case issue. So I'm willing to hear any comments. If people agree to that, let me know. So why don't we just have people, well, let's just say we'll start with the applicant and ask if they have any problems with the issues, any comment with the issue.
No comment from applicant. Thank you.
Okay. Any interveners wish to speak on the issue? No? Okay. Now the schedule, I know there's been some movement on the schedule and some agreement. So I do have, I believe, kind of current status of what's on offer here. So we had the staff proposed, original staff proposed is in the notice. And then I have the sort of the basic idea here. There's the Webco proposed compromise schedule. So I appreciate people getting together and working out a compromise. And also AEU had proposed a modified brief schedule. I think I got those dates right from the email that I received from commission staff. So I've heard no opposition to the Webco proposal. I'm willing to hear any comments about that now. So anyone propose a modification to what we have here as the well, yeah, let's work with everything but the briefs. Up until the briefs, any concern with the Webco proposed schedule?
Your Honor, Cub, we did mention that as part of the meet and confer that council is not available on March 18th.
Okay.
But, you know, I recognize that there are a great number of interveners and that the commission has a lot of scheduling to do. But I had noted that the commission's originally proposed schedule is preferable for us.
Oh, okay. All right. So I think the hearing, the actual hearing day, is Cub available on those surrounding dates? Monday is not preferred, but the Wednesday for any chance, or is it the
No,
week?
Cub is not available that week.
A week, okay. Okay, well, let's hear for other people. Anyone else have issues with the dates? Okay, so I don't know how far into the future we can set this. I'm guessing the next week would be okay for you, or no?
I'm guessing the next week is not okay for other parties, and it's also not okay for Cub.
Okay,
the previous week is
11.
perhaps
The previous week. Yeah, that might be a problem. Let me check my schedule here. 11. Well, not sure what just happened to that. Let's go off the record. Previous week, we could do, I mean, we would have the 13th and the 14th potentially. Is that something anyone else had opined on? I mean, did you get any response, Attorney Corbin Ferris, for your?
I did not propose an alternate schedule. I'm sorry that I wasn't more on top of this now, but I had, you know, definitely staff schedule is preferable for us for a number of reasons. But I did not query the group as to whether or not a March 14th or 15th hearing date might be acceptable.
Yeah, it would have to be 13th or 14th. But well, I mean, to be honest with you, I want to have a free day, second day. I'll let you know now. Although I'm not going to schedule it, but I think we probably would benefit from having it available. So we'll have a 2-day window at least for this case. Okay, so I think what we'll probably do is set it at the current proposal. It's still well into the future. Hopefully, if Cub can come up with a alternative, or we can work out another date. But I think the pushing the case out past what staff had proposed is beneficial from the staff's perspective, as well as I'm sure many other parties. So I want to keep the kind of the framework on Webco's proposal. I should have added this earlier, and this may change people's opinions. So let me get this out now, and let's get on the record for this. But so looking at the Webco proposed schedule, I wanted to add another element to this case that people should consider while we look at the timing of the Webco proposed timing. So we also have another case involved in the same location. It's the lake. It's at Lakeland, the LNG facility, which is in the same general area, and really does those cases do overlap in form and substance. So what I would propose is to actually for purposes of scheduling, combining the schedule for both cases. So so if this would be if we went with the Webco proposal in this case, we would also, and this wouldn't be actually official yet, but the concept would be to apply the same schedule to 6630 CG 140. And then for purposes of the deadlines and the hearings, we would hold all those at the same time. The records would end up being separate, but the timing of all the documentation and the hearing process would be simultaneous. So, so you might want to think about that for a minute, but the concept would be, I think as far as I could tell, you know, there would be separate records in each docket. To the extent that there would be any overlap, we would have people filing in both dockets the same testimony. But I think these cases are probably separate enough in substance, but similar enough in location, and they're interrelated in a way that makes the timing of it amenable to have these things running concurrently. And it works for us because of the proposed timing that we have before us. The later dates, the dates going out into the future, match the dates for the CG 140 docket. So since these things are kind of coalescing in timing, I'd like to keep that framework available. So I think generally speaking, the Webco proposal is preferable. The date of the hearing, we might be able to massage, but we can probably work on that depending on the needs of the parties going forward. So any comments about what I'm proposing in terms of combining for procedural purposes the two dockets? Yeah, it looks like Clean, Wisconsin.
Yeah, thanks, Judge Newmark. Just to clarify, would you be envisioning separate hearings for the two dockets?
No, the hearings would be at the same time. And the same transcripts would be just filed in both dockets. But the filings, the testimony and exhibits would be in separate filings for each docket. So to the extent we can conduct the cross and taking witnesses and crossing witnesses, we would do that all in the same session. We'd also be collecting public comments at the same time in both dockets.
Your Honor, this is Attorney Proctor Brown. I think we'll have to go back and think about it a little bit. just as an initial matter, it's actually a different statute. It's a different commodity, right? It's gas on the other side, and so there are definitely distinctions.
Right.
I actually don't know if there's overlap between the parties. I haven't thought about that, but definitely something to think about on our end.
Yep. And it wouldn't be, so I'm not gonna order that combination yet, because we haven't actually had parties identified, or and we haven't moved forward with, a pre-hearing in CG 140. So, but the idea, since this case is just occurring sooner, if the pre-hearing is occurring sooner, we set this schedule. I would anticipate if we set the WEBCO proposed schedule in this case, I would anticipate that if we need to get to do a pre-hearing conference in CG 140, that would be my proposed schedule for CG 140. So just want to let people have that concept at this point. But for purposes of today, I mean, we're only setting the schedule in this case, the issues and schedules in this case. I just want to let people know that would be my plan, is that when CG 140 comes up, we propose this schedule and the concept of hearing them simultaneously. But to address your point about the issues, yeah, they would be separate issues, separate commodity, but that's why they would really run, filings would be separate. It would just be, we would gather together at the same time, and hear both cases at the same time. So there's, when we've done this before in other cases, it's worked out fairly well. We're not duplicating efforts. And to the extent that the cases do overlap, we'll have that covered in both dockets. So that would be beneficial as well, just to be able to say, well, we have, question asked in one docket we have provided the question and answer for both. So, but you can think about it. It's not something we need to decide for CG 140 at this point. It's just something that I want people to know about. And you can think about it, and when we get to 140, you'll be able to comment on that. But just in terms of this case, and with the idea that might be happening, I just want people to let people know that the schedule in this case may apply to the other case as well. So just have that in mind while you, in case you have any other thing to say about this schedule. So I can hear comments on that.
One thing to clarify on what you have on the screen, Your Honor. I thought that the reply brief was due 4/11 in AEU's proposal.
Sure, that could be. I may have just mistyped that. Yep.
So it'd be 14 days.
So the
hearing, and then
14 days. Oh, from the hearing. Okay, I think I might have misread that. Okay, and the initial brief for AEU is that correct?
I think you have it right. So 14 days to the initial brief, and then 10 days between. But certainly, if AEU had something else in mind, I would defer to them. From applicant's perspective, that's fine.
Okay.
We would just, so long as staff is okay with those back end dates, which is I think what a lot of our back and forth in Paris Rice was about, was the back end.
Yes, and from what I understand, staff is comfortable with this. I don't know if you have want to chime in there, Attorney Bedford.
Yes, staff is comfortable with it.
Okay. So I think there's agreement with this. Like I said, we can work with CUB. They can come up with an alternative, or we can maybe push the hearing, jigger that date a little bit. I don't know if staff has what staff. So I guess the week after is not going to work. So,
Your Honor.
Yeah.
So just to clarify, are we then continuing the meet and confer process, given this new information about possibly combining this with the Oak Creek LNG case? Or, I mean, is a scheduling order is not going to come out as a result of this this discussion today? Or I'm not quite sure of the process of requesting a different hearing date or agreeing on it
Mm-hmm. Well, I guess, I mean, yeah, I was intending to set this schedule for this case in a scheduling order going out after this pre-hearing conference, but whether we combine the schedules with CG 140 or not is something we'll have to deal with when CG 140 comes up. Just wanted people to understand that that's a possibility. So that, if there's other problems with these dates, they can let us know now. I mean, the schedule is still subject to change. You could file a request to modify the schedule. If all parties and staff agree, we can make that change. I just don't know to what extent we're boxed in with the week of this March 18th, that week. So,
and Your Honor, from applicant's perspective, we definitely would like to get a schedule out of today. And I think you're exactly right. We can discuss the CG case next. I think if you compare this case schedule with the Paris Rice schedule, it starts to get really tough to move things around. But if Ms. Coburn-Ferris had a suggestion on where to look, maybe we can hash that out now. But we'd definitely like to have a schedule coming out of today.
Yeah. Well, let's go off the record again and just discuss that on another minute here. So, I mean, it looked like the week after was not going to work for the same reasons. Week of the 24th, March 24th. And I don't know how far out we can go when staff will get nervous about the end date. But and I suppose the week of the 10th, we could possibly schedule this at the end of the week. Does anyone have issues with that?
Applicants don't have an issue with the hearing necessarily, Your Honor, but then you do have to start looking at the kind of other deadlines a little bit, right? So I think
post-hearing deadlines?
No, if you move up a week, or I guess you could leave the surrebuttal deadline on the 11th, and then that's, I think, Tuesday.
Yeah.
So then the hearing on Thursday or Friday, the 13th or 14th.
Well, I think that week, I would say the week of the 10th, we could kind of manipulate the schedule to fit a hearing in that week, if that would work for everyone.
Judge, it looks like, I guess, we're also looking at the Paris schedule. I think we've got a reply brief due on the 13th. Just throwing that out there.
Mm-hmm.
Yeah, I was going to suggest if the hearing moves back to that week, the 14th would be preferable.
Yeah. How about you, Attorney Coburn-Ferris? That next week, the week of the 17th is totally out though, right? So we couldn't spill over to Monday.
Yeah, and the 14th would just be one business day difference, and that would accommodate our constraints. If other parties if that's acceptable to others, we would appreciate that.
Would this affect the reply brief date?
Probably.
Because commission staff's only concern is that we can't push the reply brief date any later than April 11th. That would be like,
yeah, it wouldn't make it. It would make it sooner, I think, if we moved the hearing.
Okay. Thank you.
I mean, we could leave it there, or we could keep the intervals the same. But
I would suggest an extended briefing. We don't usually have that amount of time for briefs after a hearing, but given the time of year, I think that it's reasonable, and also, reasonably short and also reasonably long.
Yeah, I am concerned about giving this like 1 day for the hearing, because as most of you have been involved in the last few cases that we're looking at, I think we'd benefit by having a day at least held in reserve to spill over, so we're not completely frazzled by the end. So the 13th is the Paris reply brief deadline.
Which is significant, but doable to have a hearing on the 13th and 14th.
There is 2 weeks for the Paris reply brief. The initial brief is due on February 27th.
Yeah, I see that. Yep.
I think we would, Your Honor, from applicant's perspective, we'd want to put a surrebuttal on the 7th, the Friday before those hearings, because there's just actually a lot that week. If that's acceptable to everybody.
So shorten the surrebuttal a bit.
March 7th is the Friday before that.
Okay, I'm just gonna that's probably a good idea. So I would be I would look at so if we could keep 7th for surrebuttal, how does that sound for everybody? This was the 11th. I mean, we could give you the weekend and make it the 10th. Any thoughts from staff about the surrebuttal deadline? That might be something staff would be.
Yeah, staff has no issue with that deadline.
Okay, moving it to the 7th.
Correct.
Okay, and then.
So then you could schedule the hearing for the 13th and then have the holdover for the 14th.
That might work. Yeah. What do people think of that?
We want to do I don't think we want to do the 14th and have the holdover be the Saturday. That doesn't sound.
I would rather not. Yeah, state offices are closed on the weekend. We shouldn't be working, right?
Speak for yourself.
Yeah.
I thought I was on mute. I'm sorry.
Hey, you see my emails to you Sunday morning. All right. So how does that proposal look? Surrebuttal on the March 7th, hearing on March 13th. Not hearing any objections. So, all right. Well, hopefully we can get everyone on the same page, everyone together on those days. That would be great. Okay. So okay. Clean, Wisconsin, go ahead.
Yeah, thanks, Judge Newmark. I was just going to mention back to the LNG thing. I think you're probably thinking about this, but just wanted to raise it again, like the issue with needing a holdover for this hearing and given the number of interveners and the expected number of witnesses, that I'm just concerned about holding them concurrently, even with a date built in, and just wanted to raise that concern.
Okay. Okay. Well, I mean, we can take that up when CG 140 comes. I think that's just something we'll need to deal with then. We'll see what I don't think we have, maybe confusing cases now. I don't think we have interveners yet that have actually filed, or maybe.
I believe the deadline to intervene in that case is later this week.
Right. So you're all anticipating, if not already filed, let's say.
So far, it's just Cub, Your Honor. So
right. Yeah, I see that. Okay. Yeah,
plate.
so I was anticipating maybe less interest in that case. Good luck. Okay, but yeah, we'll wait for the deadline, and then again, that whole process will need to take place. So, okay. Well, we'll cross that bridge when we need to, but I think that would be the concept. I mean, we could make it a Wednesday hearing instead of Thursday. Still have time for rebuttal is the week before, so that would certainly provide us time for more hearing time for that week. You wouldn't have a problem with Wednesday?
None from applicants.
Okay, so we'll do that. So we'll set it for Wednesday. This gives us at least the chance of following through with my plan here, my experiment here. Okay, so that looks pretty good. So let's document this then. Oh, we're not on the record right now, are we? No. Yeah, let's get on the record. So we've discussed the various proposals and concerns from parties. We do have schedule we can commit to it for the moment. We have Webco's. We'll start with the Webco's proposed schedule, and probably just read some of this out here for the record. Applicant will file direct on November 20th. Intervener and staff direct January 16th. Rebuttal February 18th. Surrebuttal March 7th. Party hearing session March 12th. Initial brief April 1st, and reply brief April 11th. So I want to mention all the deadlines are at 1:30 p.m. and the party hearing session will start at 10 a.m. I didn't poll the group here. Any preference for in-person or Zoom?
For applicants, Your Honor, I think we prefer in person is what I've heard most recently, but I wouldn't want to speak without having conferred with my client.
Okay. AEU, do you have a comment on that?
Thank you, Your Honor. I think, again, I want to speak with my client, but we would appreciate at least a virtual option. Of course, if Your Honor decides to do a in-person only, then we'll make every effort to be there in person.
Okay, so we haven't really had much for practice on this yet, but I think my preference is to always have Zoom as an option, at least for witnesses. If we are holding an in-person hearing, it's probably necessary to have the attorneys appear in person, but we can work it out if there's some, serious constraint on that part. For witnesses, I think I'd want to hear, parties should be conferring and getting together to make sure that they understand what each party's preparing to do with their witnesses. If there's an issue with the way a witness is going to appear, then they should work it out or file a request for me to decide that issue ahead of time. But I think generally speaking, I'm willing to accept witnesses on Zoom. But if we do hold an in-person or hearing in a physical location, I would most likely need the attorneys to be in person. So be at the location, let's say. So just to give you a heads up on that.
Understood.
So we can leave it kind of undetermined as long as we have the date set. And if parties do have a preference or a dire need, one way or another, I think it's probably said, why don't we have you serve each other, and I'll Attorney Bedford can keep me posted as to how things are shaking out in terms of the location, or if there's a location. Okay, so I think that's everything on the schedule for the moment. There was something else, but it's not coming to mind. All right, so in terms of, so we have a schedule issue and facilitating matters. Any comments, questions on the FMO? It's the same old one we've been trying to adhere to with some success and some not success. I did want to review just one requirement, which helps out with the process, and it's kind of what I was talking about, where you would want to be conferring with the assigned attorney for procedural matters. Just it's right at the top. Zoom this in. To make the assigned attorney the first point of contact for any procedural matters. If the attorney is unable to answer, they'll confer with me, and hopefully we can get your answer and we can get your answer to you in an efficient way. But if you have a question about anything in the facilitating matters, please contact us before you file or before you decide what to do on your own, because there's usually an answer in that document somewhere. And, you should be getting more and more familiar with this, but hopefully consulting with us as to any question will avoid the need to refile. So I'd appreciate that if we could use that resource. And a related matter in terms of emailing, I know once we get email chains going, if I'm involved in it, then I continue to get those emails, and it's really not, I'd rather not, and it's probably not appropriate for me to be hearing the banter. So we do have a section on that called ALJ Communications. Which is section D. So to send no emails to the ALJ unless otherwise indicated in the FMO, or if I'm requesting a response. So if I'm emailing everyone and I say I need to know something, then sure, I'm expecting you to respond. But otherwise, in terms of service of documents, in terms of any other related docket-related matters, please keep me off of the email chain. There is the one email where I'm requesting, just how you plan to proceed at the hearing. That's emailed to me and served to the parties. That's explicitly made in the FMO, that direction. So, yeah, I just want to mention that. So otherwise, yeah, all the filing requirements are here, and the big stick, the consequence of not filing correctly is just you have to refile, which doesn't seem too onerous, but can be as well. It doesn't seem too much like a penalty, but it can be onerous to comply with. So again, refer to this document in terms of labeling, testimony, citing to other documents, when to make a new exhibit, those kinds of things, when to request relief for something. It's pretty much covered in here. So I would appreciate it if people could consult that first before filing something. In case there are any questions about what I mean here, the first page here, we identified the parties, and I provided a identifier for each party. That is for filing, naming your filings, page numbers, and citing to other parties, to your filings and other parties' filings. You want to use this as the party identifier. And I did separate Healthy Climate Wisconsin from Union of Concerned Scientists here. to provide you an acronym for both. And what we've done in the past is if you're combining your testimony, just run those together with just a space in between the acronym. So it'd just be HCW space UCS, and you'll see how that fits into the other, how you would file something. I think you should be familiar with that. But if you're filing something separately, use the separate acronym. But if you're filing together, just combine those together. I want to keep them as separate parties. So, well, I don't know what else to cover here. If there's any questions, yes, Attorney Corbin-Farris, go ahead.
Thank you, Your Honor. Since we're all here, just to clarify your position on sir rebuttal that is filed the morning of the hearing, do I understand that it's your position that it's consistent with the facilitating matters order, that there's nothing in the rules that prohibit sir rebuttal, even though it's not in the schedule?
Yeah, let me so that's in hearing. Let's see. Where is it?
So, Your Honor, I think you did actually have it under hearing.
Okay, wasn't saying it.
Yeah, there's a point that says prior to cross-examination, number 6.
Yes. Okay. Yeah, so let's just get that up. So page 15, it's you'd cite it as F and 6 of the FMO. Prior to cross-examination, any witness may offer brief oral testimony that responds only to the last round of pre-hearing testimony or any subsequent testimony of another witness received at the hearing. Use best efforts in this matter to avoid undue surprise or prejudice. So I guess when it comes to applying this, what's expressed here in the FMO to the filing of a written piece of certiorari rebuttal, my touchstone is that I would look at this and say, this is if I look at the proposed filing, I'd say this is something that someone would say on the stand. And that, I think maybe this intent has gotten lost in the shuffle over the course of years, because we have been doing this for a number of years. This acceptance of written certiorari rebuttal has been done in the past and been done with acceptance from the parties and sometimes upon objection of the parties. But I think what's the touchstone of that standard is if it's something that appears like someone would say that on the stand, then it's acceptable to, in lieu of actually making the brief oral testimony, that you'd substitute that brief oral testimony for a written submission of certiorari rebuttal. So I think when you're looking at what's coming in, that's the way it should be viewed. That's the standard you'd want to apply in order to square the fact that we're not making a separate filing deadline for certiorari rebuttal in writing before the hearing. We're allowing oral testimony, but we'll take it in written form if it basically is just a substitute for the oral testimony. So I think another problem, what that raises though is taking time out in the hearing to so let me ask you, Attorney Corbin-Farris, first of all, did I answer that question for you, or do you have any follow-ups for that? Just the basic standard, what we would look at.
It seems like a very subjective standard, but that is helpful when when considering testimony that, we might get an hour before the hearing.
Okay, so I think there are objections that can be raised, but I think that's the standard we want to look to. And I would hope with that clarification, that's kind of the standard that will be applied to filing the SOCCTP rebuttal. So as long as we're all on the same page as what the content should be, you should be able to move forward without much controversy. Okay, so I should probably ask Webco then if that's something that you understand in terms of the standard that we're here applying.
Yeah, we do, Your Honor. I think that was a fair standard in the rate cases that we just went through. That is certainly our intent, is to keep it short, sifting, winning of the issues down to what the very last piece of testimony and only what truly needs to be responded to clarify the record. There aren't that many days ever between rebuttal and the hearing, so that's a natural limitation on the kind of testimony that we would submit as written testimony. And it really is just to avoid having each one of those witnesses come up and read it into the record as if it was purely oral testimony. So I appreciate you clarifying where in the facility matters order that exists.
Okay. All right. So then the other part that may relate to this is if we will be having a Zoom component of the case, and that means that we will also need to apply the audiovisual supplement to the case. So there is a standard here for preparing for the hearing that involves providing documents. So let's see if I can get that. So there should be, here we go. So on the audiovisual supplement, page 4, line 5, we do have a note here that for any document for any document not on the offered evidence list that a party or commission staff wishes to use at hearing, the user shall share that document via email to parties, commission staff, and the ALJ no later than 1 day before the party hearing session at 1:30 p.m. So I think this would I think the SOCCTP rebuttal does trigger this requirement. So I think in the future we'll want to see more advanced notice for any SOCCTP that comes in writing. So we will be so there's really no opportunity. I mean, it's not the same to come to a hearing with the documents. If we are going to have a Zoom component, then we won't be able to pass documents out in person to everyone at least. So this requirement would apply. So be sure to have documents served by 1:30 the prior day. And if that's not possible, then we'll take the witnesses on the stand. That's just how, if we need to do it that way, but that's what we'll do. But I think in terms of squaring all these different elements together and following the rules that we have in place, that would be something we'd want to see more advanced than the morning of for SOCCTP rebuttal. So to follow the deadline for 1 day before 1 day before at 1:30, I think would also alleviate some other concerns that people have. So so is there anything else on the SOCCTP? Oh, sorry. And you can just, when I'm done, I'm asking for anything else, just go ahead and chime in. You don't have to raise your hand. I don't know if other ALJs or whoever is asking you to raise hands. I don't usually pay too much attention to that. So if I'm saying, give me your comments, let's just chime in and you can speak. So go ahead, Attorney Vijayकर.
Thanks, Judge Newmark. I'll keep that in mind. This question is not specific to Sir rebuttal, but is prompted by your discussion about the Zoom conduct.
Mhm.
I assume, based on the language in the FMO, that the 1:30 deadline in the Zoom context, you expect that impeachment exhibits would also be circulated in advance. I know in some cases those are handled a little differently than, other documents that we might want to use at hearing. So just wanted to raise that with you to see if you had any thoughts on whether impeachment exhibits would be subject to the same deadline.
Yeah, I did not specify that. I think it might have actually been in there at one point, but it was taken out. So you can make a case for that, I suppose.
Yeah, I mean, I guess I'll go ahead and make a case for it. I mean, in my view, or I'll say in AE's view, impeachment exhibits, the whole point of impeachment exhibits is to use them on the stand and address testimony that the witness is giving or has given. And the element of surprise tends to be more important with an impeachment exhibit. Obviously a different case to be made about a substantive exhibit that we plan on discussing at the hearing. So in my mind, there's value to applying a different standard to impeachment exhibits as far as the timing of when that exhibit should be made available to the parties. I'm fully in favor in the Zoom era of non-impeachment exhibits being made available to parties and to witnesses ahead of time, so everybody has those in hand. But I think AU would be supportive of a different timeline, and maybe none at all, to be applied to impeachment exhibits.
Okay. Anyone else want to comment on that?
Yeah, applicants would like to, Your Honor. It's our understanding that that provision of providing all exhibits that you're going to use at the hearing by 1:30 the day before would apply to impeachment exhibits. This is not a trial with surprise witnesses. This is a proceeding with pre-filed testimony. So by the time we get to the day before, particularly if Sir is going to be subject to that deadline, exhibits that you use with witnesses during this 1, maybe 2-day hearing should be provided the day before at that 1:30 deadline. That would be our position. I think that's what we've done in every case since you've had this audio-visual supplement, to my recollection.
Anyone else? No, we can't get one vote for one way or the other, so I can. Yeah, I think we're going to hold the deadlines the same. I think just in terms of procedurally administering the hearing, I'd like to get documents in ahead of time because I don't want to be waiting and really the element of surprise just rarely comes up in these cases. I don't think it's going to be critical. And we do have a lot of time for witnesses to prepare, reading pre-hearing testimony. In terms of impeachment, it's pretty rare that I've seen that happen here, and I'd rather just keep a standard for all filings so that we're not trying to shuffle and trying to find documents on the day of the hearing. So for an efficient process, we'll have all those documents come in at 1:30. I think actually we might not have applied this to the last few rate cases for the applicant. So I think we did receive those SOCCTP documents the day of the hearing, but I guess we'd have to check back and make sure. So just so we know, going forward, let's stick to the day before 1:30 p.m.
You're right about Sir, Your Honor. What I meant was exhibits that you use on cross-examination. I think every time I've seen one used, it's had to have been provided the 24 hours in advance.
Right. And I think there may have been some earlier versions of the hearings, the audiovisual supplement where I exempted impeachment documents, but it's no longer there. So, but yeah, you're right. Okay. Anything else? No? All right. So I'm not sure. We don't have anything pending before I come up with a pre-hearing conference memo we do have everything settled so far in this case. And like I said, the extent to which we combine this with another docket, we'll have to hear that in CG 140 to put that case on the same track as this one, which hasn't been decided yet. But I just wanted to give everyone that heads up that could be coming. So no worry, don't get too nervous about that. We'll deal with that when it comes. All right. So anything else? No? All right. Thanks very much then. We're adjourned. Take care.
Your Honor, before we, off the record, but before we
Your Honor.
leave.
Did you say off?
I guess so. I'll just say what you're going to say. What's going on?
Yeah. When were you thinking that we would have the pre-hearing conference for the other case?
I don't know. That's not.
Okay.
Yeah. We, I don't even know. So we have a notice of proceeding and the intervention period hasn't been closed. So it's going to be, I would expect, several weeks, maybe. We have to notice it. And so it would be quite a bit of time. There's always possibility that parties would agree to a schedule and issues, so we would forego actually doing the pre-hearing, but I would expect staff to be proposing this schedule. So the schedule we just made here as the staff's proposed schedule. So we already have that settled. So why do we need to do a pre-hearing? All right. So
thank you, Your Honor. Sorry if I've hijacked this. I just wanted to see if you had a sense of that.
Yep. No, not quite, but yeah, you know where I'm going.
Yep, for sure.
Okay. All right. Well, thanks everybody. Take care. We're adjourned.
Thank you.
Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Judge Newmark.